You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And excited to be back for another day, making it through the coronavirus, God willing. And this morning, it was funny because you see this on Facebook and Twitter, and and you wonder, is that really a thing? Because I hadn't seen it in person yet.
Yeah.
And I was at Publix this morning, just buying some half and half for the office, and the guy in front of me, the checkout line, was just cleaning out the Angel Soft in the store, and I just laughed because I just had not seen that in person yet. So anyway, that for those of you who have seen that on social media and you think, there's no way people are not that crazy. They are. It's happening. It's a real thing.
And by the way, we don't get any remuneration for naming products on our show.
Right. That's true.
Yeah.
That was
gratuitous.
Free. Yes,
that's all right.
So,
any other products you'd like to endorse today before we get started?
That was it.
Okay.
That was it.
You weren't buying it though.
No,
so you're not endorsing it.
Right.
Yeah.
I couldn't even tell you. I think I just.
No, that's all right. That's all right. We don't need to. Yeah.
All right. We'll leave that alone.
We are extravagant here. We actually do buy generic half and half,
right,
instead of just powdered plastic.
Okay.
So let's get
Moving
into
on.
the subject. Yeah.
So Today will be good because we're going to be talking about some 14th Amendment and Fifth Amendment issues in the courts, of course, as we've been harping on for quite a while. But one thing that I just really connected the dots this morning that I hadn't yet, because it's kind of in what we're talking about today, this word liberty.
All right.
And we've talked a good bit. I know I've heard 2 or 3 times in your testimony on the abortion bills currently going through legislature that we've talked about how in the Roe v. Wade decision in 1973 that decision was basically extrapolated from the judges sort of reinterpreting the word liberty in the 14th Amendment,
right,
and giving a woman a liberty right to have an abortion,
right,
which creates a whole host of issues. But also just hadn't really connected the dots and thought about, that's exactly the same way that the court treated the Obergefell v. Hodges decision in 2015, which of course is a decision we've talked about at length on this show.
Sure, about marriage.
About marriage, yeah. And
that there was a liberty right
there. There was a liberty right based on equal dignity. That was all extrapolated for those judges from this word again, liberty in the 14th Amendment.
Right.
And so we want to kind of hash that out because there's these. Number one, we've talked about, those same words, life, liberty, and property, are in the Fifth Amendment.
Right. And
it would make sense, right, if they meant the same thing?
It would.
in both amendments.
That's right. You would think so.
And currently, it seems as though they don't.
Well, that would be sort of the question that you would want to ask, because most cases nowadays don't deal with life, liberty, and property under the Fifth Amendment. They deal with the 14th Amendment against state laws. We typically we see most of the cases actually we don't see a whole lot of cases under the Bill of Rights per se anymore. Most of the cases are lawsuits against local governments and states based on the 14th Amendment. And people need to realize, many people do not know this, but there's a case from the late 1800s, early 1800s, I can't remember, but Barron versus the state of Maryland, I think it is, or Baltimore, one or the other. But the Supreme Court made very clear that the Bill of Rights, the first 8 amendments to the Constitution, and number 9 and 10, but the first 8 deal with rights, speech and religion, search and seizure, incrimination, double jeopardy, all those things, that they only applied to actions by the federal government. States were free to do whatever they wanted to do. Most people don't realize that. We've lived under the 14th Amendment so long, since shortly after the Civil War, that we don't even realize the Bill of Rights itself, in particular, did not apply to the states. So, for example, there's a provision in Tennessee's Constitution, which is from 1870, yeah. And it still refers to the state having the power to regulate the wearing of firearms and the carrying of firearms for purposes of public safety. Because at one time we thought the states could do various things that now by the 14th Amendment they can't. And that's a whole legal argument, but people need to appreciate why it is that states get into trouble over religion and abortion and marriage and all these things. It's because of the 14th Amendment. And so that's just an important point. People don't know that. Like a lot of people don't know that, the state legislatures used to appoint the United States senators. That got changed by constitutional amendment. But what the 14th Amendment has allowed the court to do is to begin figuring out, well, what things can states do and not do? What is the list of things that they can and cannot do?
Well, it seems as though they've leaned upon the 14th Amendment to sort of become a legislative body.
They have, and that's kind of what we want to talk about today. And Justice Breyer, in particular, has put himself in such a contradictory, self-refuting, impossible situation, and but for the fact that he's a Supreme Court justice and his decision constitutes 1/9 of let's say the supreme law of the land, if you take,
as some would
would say, it's scary for a person to be so inconsistent and incoherent in their understanding of their function. That's a terrible thing. And we talked a bit about it last week, but this week I think we ought to dive more into it. And something he said actually last week when the Supreme Court was debating the abortion law out of Louisiana, the Fifth Circuit decision, and they were trying to decide if the Louisiana law was constitutional or not. And so he made an observation, and maybe we could use that observation as a starting point for trying to understand this problem with liberty and the crunch that's taking place on states where they can't even decide who can get a marriage license.
Yeah, and again, this was a comment by Justice Breyer just last week.
Right, during the oral arguments.
Yeah. He said, and while they were having conversation, he said, and in Casey, referencing the Planned Parenthood Casey decision, and the latter cases, I think personally the court is struggling with the problem of what kind of rule of law do you have in a country that contains both sorts of people. And just previously, the people he's referencing, there were people that basically feel that abortion is morally wrong, and then other people who feel the opposite.
Right. So how do we develop a rule of law here, a principle? Now, the one thing people need to appreciate, we use the word rule of law from time to time, or we've heard it, and there were certain things that were said to be true when the rule of law exists. When it's when something is consistent with the rule of law. And that was that the law had a sense of permanence, that it just didn't change from day to day to day. And, today you can do this, today you can have abortion, tomorrow you can't, next day you can have infanticide, the next day you can't, or every few months or every year. So it would have a uniformity. It would apply equally to all situations and circumstances, and that it would be true as uniform, permanent, and universal. It would apply to all similar situations. So one of the problems we've said, for instance, with the abortion decision is that the phrase life, liberty, and property, no person can be denied that without due process of law. Mm-hmm. The question is, well, what's the word person? Whatever you interpret the word person to mean, it should be equally suitable to apply to life and liberty and property. It shouldn't vary oh, well, person means this when it comes to life. Person means this when it comes to liberty. Person means this when it comes to property. The word person applies to all of them. It's the subject for all of them. Well, the problem is we treat the unborn as persons in all of those areas where it would be appropriate to treat the unborn as persons. They can have property. They don't really have liberty in the same sense that you and I can move around, but they can have property rights, and they can lose their life. I mean, we have laws against fetal homicide apart from abortion. So the Supreme Court's decision regarding what a person is and the protection of law that persons have and life and liberty and property violates the rule of law, because it interprets the word person differently based on what kind of actual medical procedure you're having. Okay, so Breyer, I would suggest, is saying we're really struggling with the rule of law problem here. But I think here's his particular problem, but people need to appreciate this. In 2016, the Fifth Circuit upheld a law almost identical to Louisiana's.
Yeah, the Hellerstedt case.
Hellerstedt case, Whole Women's Health versus Hellerstedt. And they said it was and the Supreme Court reversed and said, no, this is an undue burden on a woman's right to
on her liberty.
That's right, on her liberty. And they talked about the credentialing processes for hospitals and the admission processes and all of that, and how many doctors were available and how far apart abortion clinics would be. And they said this law has the effect. So maybe it's not its purpose, but Roe and Casey talked about the purpose or effect of a law is an undue burden. So they said, well, the effect of this law is a real undue burden. Some women are going to have to drive 350 miles to get an abortion. Well, Louisiana has the same law. Fifth Circuit said, I heard what the Supreme Court said, so now I'm going to do what you did, and I'm going to evaluate distances and credentialing procedures and hospitals and how close and how many they are and blah, 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 blah. And I think now it's not an undue burden, and I'm going to uphold the law again. So the Supreme Court 2 weeks ago was, this would have been, what month are we in now? March. End of February, I guess, or early March. They were debating that. And so what Breyer was saying is, gee whiz, I'm having to weigh all these factors of distances and credentialing and all this to figure out whether the effect of the law is an undue burden. And how do I develop a rule of law there? Am I going to come out and say, well, here's the rule of law. If doctors can be admitted under these conditions, and you have so many hospitals per city or geographic area, and if an abortion clinic is within so many miles, then the rule of law is you can have a admitting requirement. Now, you see what's taking place there? You're really making a legislative decision and weighing different policy factors and considerations. And he's now saying, gosh, I'm having to act like a legislator. How do I come up with a rule of law? Well, you can't, Justice Breyer. Yeah, you can't. Because the Constitution doesn't say anything about how close an abortion clinic has to be to a hospital, and it doesn't say anything about who can perform abortions, and it doesn't say anything about how close they have to be able to be to the hospital and whether they have admitted. You're just having to rewrite the whole Constitution, and you're struggling with that, aren't you?
So it's clear that he's struggling with it because he's realizing that as a judge, he's having to weigh policy decisions.
That's right.
Which really isn't in his wheelhouse.
Which isn't in his wheelhouse. That's exactly right. And we should leave that up to the people of Louisiana to decide how they want to do that, in New York and Virginia and Tennessee. And if they make wrong judgments and weigh the policies wrong, we run against them, we kick them out of office, we change the statute.
Right.
But now he's got to come up with a rule of law so that every judge across the country can now figure out, how do I, in the next case, weigh the benefits and burdens to decide what the effect is. Now what's not only a problem there, he's having to act like a legislator, and that's a problem. He can't even be consistent in his own application of his understanding of how to interpret the Constitution. And I thought we might want to talk about that. He made some really hypocritical things when it came to gun rights.
Yep.
See, he likes abortion. He doesn't like guns.
Right.
Now, you would think that that would not change the way you evaluate the Constitution. It's kind of like the baseball umpire. We don't have one set of strike zones for one umpire, and a different umpire says, "Now I have a different strike zone." Now, we all know they may see the pitch in a different way, but the strike zone's technically defined the same way for every judge. So you wouldn't think it would matter whether the guy's throwing a curveball or a fastball or a slider or a spitter or whatever it is. That's the strike zone. So we got abortion, and he's supposed to call balls and strikes. That's the infamous statement of Roberts. We're a court that calls balls and strikes. Here's the strike zone. Were you in it? Were you out of it? So it shouldn't matter whether I'm talking about abortion or guns. The same principles of interpretation of calling balls and strikes should apply. Now let's look at what he did in a gun case from a couple of years ago.
And what we see too is that oftentimes, these justices allow their ideologies to affect how they look at the law and how they look at these amendments. And this statement by Breyer in this, McDonald versus City of Chicago is a gun rights case.
Right.
He kind of shows his cards. He shows his hand.
Sure does.
Right.
Now, for people to understand, City of Chicago thought it was good to ban handguns.
And so obviously here they're talking about the Second Amendment.
The Second Amendment, right. But again, whether you're throwing a slider or a curve or a knuckleball, the strike zone doesn't change. And so the case came up to the United States Supreme Court. Could Chicago ban these handguns? And the Supreme Court reversed and said, no, you have a Second Amendment right to contend with. To contend with, right.
And so he says.
But Breyer dissented. He said, no.
Yeah.
It's perfectly fine. Chicago should be allowed to do this.
Yeah.
Now, this is what he said.
Incorporation of the Second Amendment right would amount to a significant incursion on a traditional and important area of state concern, altering the constitutional relationship between the states and the federal government. So in his dissent, he's saying, hang on a minute. We can't use a constitutional amendment and just shove it down the throat
under
on
the Bill of Rights.
Yeah.
See, because that doesn't, Second Amendment didn't technically
right.
apply.
Those are federal issues.
Those are federal, right. Now he wants to say, we shouldn't incorporate that into the 14th Amendment. We shouldn't make that apply to the states. We should leave that one alone.
Yeah.
And the majority said, no, that's so fundamental. Yeah. It's spelled out in the Second Amendment.
And why would that be, perhaps? And he's a liberal. And he's against gun rights.
So now all of a sudden, he's for not interfering with state sovereignty. He's for the federalism.
States are sovereign. They should make their own
That's
laws.
Right. And now we're going to tell them how to define marriage. And we're going to tell them that they can't protect the unborn.
Right.
Now, why did he not care about the incursion in traditional important areas of state concern when it came to abortion and marriage?
Well, I love his statement just a couple sentences down. After he says that, he says, if we do that, well, that's going to force judges to answer difficult empirical questions regarding matters that are outside of their expertise. Yes. No joke.
Yeah.
That's the point.
So here's where he comes on later, explaining that second point, is he said, well, if we incorporate the Second Amendment into the 14th Amendment and say that the right to bear arms can't be infringed by the states, not only have we interfered with the state's sovereignty, that's a terrible thing, unless it's marriage or abortion, but we're going to have to make these empirical decisions. What is he talking about? One, it will require judges to assess the cost and benefits of firearm restrictions and thus make empirical judgments in areas in which they lack expertise. Well, we don't know how to weigh the crime problem in Chicago versus the need to have a handgun and what the cost of handguns and whether it'll reduce crime or increase crime. We're not set up to do that kind of policy-making thing.
Correct.
Great point. But now, why doesn't it apply to abortion? You're just sitting over here 2 weeks ago lamenting, how do I create a rule of law? Because I don't know how to weigh distances to abortion clinics and hospital admitting privileges.
He's not a firearms expert, but he's a medical expert.
Yes, that's right. Yeah, he's an expert for weighing what is an undue burden on abortion. But I can't be an expert as to what constitutes an undue burden on the right to carry arms versus controlling crime.
Right.
The man's just a flat-out hypocrite.
Mm-hmm.
And it just kind of reminds me of the scriptural point that, the man who lacks a foundation is tossed to and fro by every wind of doctrine.
That's some truth right there.
Yeah. And in our country, we don't quote govern by the Bible as institutionally. We didn't incorporate the Bible into the Constitution. But the Constitution, in essence, served as our Bible for our civil government's authorities, powers, and the relationship and balance of powers between the various governments. That's our Bible. And so like a typical liberal who takes the Bible and goes all kinds of places and winds up in all kinds of crazy places because now they're contradicting themselves. God is sovereign. Oh, but not over coronavirus.
Yeah.
That's just a freak of nature.
Yeah.
God is...
Yeah, he's not going to be able to control that one.
Yeah, no, he can't control that one. So which ones can he control? Well, I'll give you my opinion. Well, I'm not interested in your opinion. I'm interested in God's opinion about what he's in control of. He says everything. Mm-hmm. So, okay. Now you do the same thing with the Constitution. You start saying, well, I like this right in the Bill of Rights. I think I'll apply that one to the states. Oh, I don't like the Second Amendment. I'm not going to apply that one to the states. On what basis? Why are you applying the First Amendment or the Fifth Amendment or the Fourth Amendment to the states, but not the Third Amendment? Or what's your principled reason for doing that?
Yeah, simply what I believe.
What I believe. Yeah. Now, what was ironic is just literally yesterday, there was an article that kind of blew up in another sort of major news outlets about a federal judge. I can't remember if it was a circuit court judge or a district court judge, but she's publishing a paper.
Yeah, Adelman.
Adelman, in the Harvard Journal of Law and Policy.
Right, due to come out soon.
Yeah, and she's all upset about the Supreme Court and Justice Roberts.
She's firing at Roberts, yeah.
Yeah, and what she's complaining about is the court. I don't know if there's a good quote on there, but about the court's undermining democracy. Is there a quote on there?
Well, it just says, one of the things she says is the decisions of the Roberts Court are contributing substantially to the fact that ordinary Americans have so little political power.
Yeah, they have a little political power. It's upsetting our democratic institutions. And I want to say, do you not think it upsets democratic institutions for Justice Breyer to take the word liberty out of its common law context and say, oh, it confers dignity on people and your marriage license undermines dignity?
Yeah, how about when justices decide
and we're going to overrule 38 state constitutional amendments?
Yeah. And they use the court to wield political power.
Sure. Now, that justice might say, well, the reason I'm doing that is because the ballot box doesn't work anymore. Legislators are corrupted by the influence of money and special interest groups. Well, if that's the case, shame on us as voters. Shame on us as elected officials. But don't say, therefore, to fix it, I'm going to get out of my lane of judging particular disputes between particular parties over particular laws, and I'm going to start upsetting the democratic process by overruling 38 states' constitutional amendments on marriages. And now I'm going to intervene in 48 states, or maybe all 50 states, that had regulations on abortion, because that's now liberty. Well, where did your notion of liberty come from? And how far does it go? I mean, what's your rule of law principle by which you interpret liberty now? Is liberty just what 5 people think it ought to be in a particular situation, and now I have liberty to do that?
Yeah, at what point do we stop defining the word liberty?
Yeah. So, maybe if you're poor enough, you have liberty to steal. I don't know. Well, why would we say we wouldn't? So that's really important, and Justice Thomas is probably the person who best understands that.
Yeah, especially regarding specifically the issue of what this district judge or federal judge had talked about. Americans having so little political power. There was a statement I love. So you brought about Justice Thomas's dissent from the Obergefell v. Hodges case,
right?
And he
It's
makes
worth reading for people.
Yeah, I mean, the whole thing is fantastic. But he addressed, sort of mocked almost this specific issue, and he said, by straying from the text of the Constitution, substantive due process exalts judges at the expense of people from whom they derive their authority. But then he goes on to kind of juxtapose two things. He says petitioners argue that by enshrining the traditional definition of marriage in their state constitutions through voter-approved amendments, the states have put the issue beyond reach of the normal democratic process. So what he's essentially addressing the gay lobby right here in this particular instance.
Yeah, and we all went to the polls and voted, and
Right.
that somehow puts it beyond the reach of the
I mean, isn't that the democratic process?
Yeah, isn't that the
A
democratic
group
process?
of people voted on an issue,
Yeah,
and the majority decided that
and because we lost, it's now
now that's no fair.
Now it's outside the democratic process.
So he says, but the result petitioners seek is far less democratic. They ask 9 judges on this court to enshrine their definition of marriage in the federal Constitution, and thus, per Thomas here, he said, and thus put it beyond the reach of the normal democratic process for the entire nation.
For the entire nation.
Yeah, if you want the courts to make this decision for you, well, that's putting it outside of the democratic process.
So some of what this judge over here, Lynn Adelman, is complaining about is when the court restricts itself to calling balls and strikes and not making up words and giving words new meanings, you're undermining the democratic process. And it's like, no, I'm allowing it to work. I'm leaving more decisions up to the people and their representatives to make. And that scares you to death as a liberal because you don't think people are capable of making any appropriate decisions, and when they find them wrong, fixing them.
Which isn't that exactly
You're
why
an elitist, arrogant, pompous person who thinks only certain people can make correct decisions and correct them when they're wrong.
Because they're the smart ones, David.
They're smart ones. Yeah, they went to Ivy League schools. And I didn't. I was reminded by one legislator multiple times that he went to Harvard. And I didn't. And he's no longer in the legislature. Outlasted him. People got tired of being reminded that he went to Harvard, I guess. And of course, he was pro-abortion.
Right.
But in any event, that's a segue here. Yeah, it's very undemocratic. And Thomas, you mentioned a word that many people don't understand. It's called substantive due process. And that's what Thomas said. He says, by straying from the text of the Constitution.
I glazed over that, David, because I don't have any idea what that means.
Well, I'm going to explain it now. Right. Substantive due process, okay? Now, when you think of process, you don't think of substance, okay? So the legislature, here's what I will often say, is a law good because it went through the legislative process, it got a majority of votes through each committee, it got a majority of the votes on the House and the Senate floor, and it's the law. Is it a good law substantively? Well, no. It says you can kill babies. It says we can redefine marriage. It says we can steal each other's property, or if your income's below a certain amount, you can steal people's property. That's a bad law. Well, but it went through the process, and it did everything the process required, so why isn't it a good law? Mm-hmm. You see, this is one of those things that we can't deny the truth that's written on our heart. I often said, I never had anybody come to me and say, that law, David, we need to repeal that law because it's a bad law. And I said, you mean it didn't get 17 votes in the Senate and 50 votes in the House and the governor failed to sign it? Oh, no, it got a majority vote in both houses and the governor signed it. Well, then it's a good law, isn't it? Well, no, it's a bad law. Why? Because there's something outside the process, substantively, outside our reach, that says that's bad, substantively, you see. We have a law written on our heart. We know certain things are wrong. Now, we're terribly inconsistent with it. You know, we're great with socialism until somebody takes my wealth after I finally accumulated it. We're right with all kinds of things until, as C.S. Lewis says, somebody breaks the queue at the bus line on us. And then all of a sudden, that's not right. There is a law outside of us that presses upon us all the time. And so Peter writes that we should commend the good and punish evil. And never had anybody say, I would like for you to pass a bad law. I would like for you to not pass this good law. Never. 12 years that I was in the legislature. Never said that. The question is, who defines good and evil? What is good and evil? But we know there is such a thing. And we know that you can actually follow through with the process and it be terrible. We know that. So what does the due process clause talk about? Oh, it talks about due process. Oh, that sounds like process, doesn't it? But see, what happened is judges began to say, well, it needs to have a substantive component. So what they then want to do is take the word liberty and life and property and begin infusing those words with substantive meaning.
Which is not their job.
Which is not their job, as we heard Adam McLeod say. And in the testimony last August on the abortion hearing, it's up to the legislative bodies, the states, to specify the rights and decide how to protect them. Now, that doesn't mean that the legislature can just say we're going to ignore the issue of life completely, because it does say you can't be deprived of life, okay? But it says without due process. I can be deprived of life. We do it all the time. I can be deprived of liberty. We do it all the time. We say, here's a law. You can't break into that person's house. So you can't be deprived of liberty without due process of the law. Okay, there's the law. It says you shouldn't get into that person's house at night and carry a gun, okay? And we're going to tell you that that law is there. We're not going to hide it somewhere where you can't know that you shouldn't be doing that. We're going to then give you notice that you did it, and we're going to give you lawyers, and we're going to have a hearing, and you're going to go in front of your jury of peers. And if they find that you did that, we're taking away your liberty. That's what the due process clause is about.
Part.
That's right. That's the due process part.
And the court simply needs to ensure that that process takes place.
That's right. And say, is there a liberty here at stake? Yes, there is or is not. Now, were you deprived of it without due process of law? The problem is the judges start taking the word liberty and making it mean things that it was never intended to mean. And Clarence Thomas talks about that in his dissent in Obergefell. What was the meaning of the word liberty? And I don't know if we've run over our time today or not, but Thomas talks about what the word liberty meant, and I think you may have it there in front of you, but
well, he says the majority claims these states deprive petitioners of liberty, but the concept of liberty it conjures up bears no resemblance to any plausible meaning of that word as it is used in the due process clauses.
That's right.
So he's saying, you're saying they're depriving of liberty, but your meaning of liberty is really off the rails.
Sure. And so what does he go back to say, so what does liberty mean? What did the framers think it mean?
He quotes William Blackstone.
Wow,
Look
haven't we quoted him before? Yeah, he says it bears no resemblance. So he goes on and says,
the justices of the United States Supreme Court harken back to common law?
Yes, and William Blackstone, which is exactly what we're urging them to do on the abortion issue.
Yes.
We can't get anybody to pay attention in the Senate. Can't get anybody in the administration to pay attention to the Senate that that's a normal standard of construction of the Constitution.
I mean, Obergefell, this is 2015. We're not talking about ancient history.
But he's quoting what also the majority's been doing for hundreds of years. They've looked at Blackstone and the common law.
Yeah.
I'm not coming up with something new here. I'm not that bright. So he says, as used in the due process clause, liberty most likely refers to, quote, and he's quoting from Blackstone, the power of locomotion, of changing situation, of removing one's person to whatsoever place one's inclination may direct, without imprisonment or restraint, unless by due process of law. So, for instance, I can walk anywhere I want to, but you can't trespass, and that's Gary's house, and you went in Gary's house. Your liberty does not extend that far, and I've passed a law so that you know it doesn't. And now when I prosecute you for trespass, we're going to give you appropriate process. But liberty is moving around. It's not liberty to have a third person kill a baby. Liberty is not necessarily the right to marry whoever you want or how many ever people you want.
Or define yourself however you want.
Yeah.
All those sorts
the state license your law on marriage does not prevent a man and a woman from marrying. It just says it needs to be a man and a woman, but you can move anywhere you want. You can even live together. You can have lots of sex together. But that doesn't implicate liberty, and there's certainly no lack of due process in it. Everybody knows what the rule is for a license, and here's how you do it, and here's how you go about getting it. There's no violation of liberty and due process here. So when you quoted that, when we stray from the Constitution, say we get away from what it was originally intended to mean, we start infusing new understandings of liberty beyond the power to move around and locomotion and not be restrained except by due process of law. So yes, I cannot decide, you and I can't decide to have a little parade to promote the God, Law, and Liberty podcast at midnight down the street in your neighborhood. We might have to get a permit to do that.
Right.
Okay? But one of the things that Thomas then also pointed out, and this is important, he said, when read in light of the history of that formulation of the word liberty, what it was meant, it's hard to see how the liberty protected by that clause, the 14th Amendment, could be interpreted to include anything broader than freedom from physical restraint. So he said, it's hard to see when you just think about how the word liberty could be anything more than being locomotion and moving around and not being falsely imprisoned and restrained and so on and so forth. And he says that's the consistent usage at the time when liberty was paired with life and property. And then he says this, that usage, so limiting liberty to the concept of moving around and locomotion and not restraint on the use of your limbs and all that without due process of law, avoids rendering superfluous the protections for life and liberty. In other words, liberty could be so expanded if we start infusing bigger, broader meanings into it that the word life and property...
Why even list life and property at that point?
Liberty is everything.
Yeah.
Okay? But here's the flip side. When you limit the definition of liberty to locomotion and movement and restraint, you don't run into life and property. You don't wind up saying my liberty includes killing this third person.
Right.
Or enlisting a third person to kill another person.
My liberty trumps this person's life.
That's right. So what the whole common law was, and Adam McLeod testified to this, is it's this notion of long-standing developed customs where we've figured out, if I interpret the word liberty, really big, well, all of a sudden life and liberty are now in conflict with each other, and I can't put those three words together. See, that's what Thomas was saying. When the word liberty was paired with life and property, we had to have an understanding of each of those so they weren't constantly killing each other.
Yeah, they each had a specific meaning.
They had a specific meaning, and over time we'd figured out if we expand the concept of liberty too far, we run into property and we run into life. So this is what that means. Now here's what life means. Life means a natural person, all natural persons. And wherever that natural person might have some right, like to actually live, then we'll protect it. Or where it might actually have some right to property, we'll protect its property rights by not letting you, take away an interest that your descendants or issues might have in the trust that you've developed. Okay? But so that's where the Ninth Amendment argument comes in on the abortion issue. Is it says, look, the enumeration of rights, the spelling out of life, liberty, and property in the Fifth Amendment, and the spelling out of life, liberty, and property in the 14th Amendment, you shall not construe those words to deny other rights. So when you start giving an expansive interpretation of liberty, you start denying other rights, namely, in this case, the one to life. And the Ninth Amendment tells the Supreme Court, you can't do that.
Well, and our friend Justice Breyer helps us out again with that. He's going to pull out another statement out of this Chicago case.
Yeah.
Because we have some folks here in Tennessee that love to quote Marbury versus Madison.
That's
so
right.
much.
Oh yeah, that's a great quote.
Justice Breyer quotes that case and says, "It cannot be presumed that any clause in the Constitution is intended to be without effect."
Yeah.
Essentially, he's saying if it's in the Constitution,
It must mean something.
It has meaning.
Yeah.
And we need to use it.
So the Ninth Amendment must mean something.
It must.
Yeah. Now, this is what's important. This is really important. When the Supreme Court decided the Casey case in 1992 on abortion, it said, look, we have to have an equally rare precedent. We talked about this in the last podcast. Because we've now interpreted the word liberty a certain way. Yikes. Okay, we did. But I ought not change that unless you can give me something else rooted in the Constitution that is equally as rare as what I had to do in that other case. Because otherwise, I'll lose my legitimacy. I'll just look like I'm flipping based on how many judges of a certain philosophy are on the court at any one particular time, and the Constitution's interpretation changes based on who's on the court. We can't do that. We'll lose our legitimacy. So you got to come forward with some equally rare precedent, and you must make your argument based upon accepted standards of precedent. We talked about that. So what are we doing with the Rule of Law Life Act? We're saying the Ninth Amendment exists under Marbury versus Madison, which is the case even all the liberals like to rely on. That Ninth Amendment must mean something. And what does it mean? It means the other rights. That means that there are rights that exist prior to politics, prior to government, prior to constitutions. Well, what were some of those rights? Well, the absolute right to life was one of them at the common law. Oh, well, we put that in the Constitution, right. But here's what you did, you lummox. You interpreted the word liberty beyond its common law understanding so as to overtake the word life. Now get back in your lane. The Constitution forbids you from doing that. You cannot construe the word liberty to deny the right to life. Period. End of the discussion. That's a rare precedent. It's never even been argued. Now, does the governor's bill, his laddered approach, do any of that? No.
Zero.
I'm not calling anybody a bad man. I'm not saying their heart's wrong. I'm just saying if you want to see Roe versus Wade reversed, you only have one choice. That's to make an argument rooted in something in the Constitution and argued according to accepted standards of precedent. The governor's bill offers no constitutional provision and no precedent. Not being mean, it's just the truth. It doesn't. What does our bill do? It says the Ninth Amendment exists. Under Marbury versus Madison, it has to mean something. What are the accepted standards of precedent? Well, we've been quoting Blackstone off and on for 17 podcasts that the court looks at. There we go. We've given the court what they said they wanted in Casey. Now they could reverse Casey without looking political by saying, we've never been asked this before. Remember when we talked about Thomas last week or 2 weeks ago when he said, I don't even want to hear the case from the 11th Circuit saying it was unconstitutional to ban dismemberment abortions. And why? Because he thinks they're wonderful? No, he said, because you didn't ask me the right question.
Right.
You didn't give me what I needed to not look political. So even a man who says this is demonstrably wrong, Roe and Casey are demonstrably wrong, I'm not going to hear your case. Because you didn't give me what I needed to maintain the integrity and the legitimacy in the eyes of the public of calling balls and strikes, and so I'm not going to hear your case. But now you come in here with a provision of the Constitution in this context that we've never considered, and we've never considered in any context, and you quote to me how we're supposed to interpret the Constitution and the way we're supposed to do it, and we've been doing it for 100 years. Now I got something to think about.
Well, and like you said, as we close up, isn't that what they, we talked a while back about these breadcrumbs that through all these decisions throughout the years that even folks like Ginsburg and just people have dropped throughout the years that if you want to overturn this precedent, this is what they're looking for. And it's funny that, we've had folks here in Tennessee argue, for example, against our Rule of Law Life Act, our conception bill, that, it's too radical. It's too much, and no one's ever done this Ninth Amendment thing. In fact, in August, National Right to Life sent their pit bull, Jim Bopp, down here to tell the legislature essentially that, that David Fowler's crazy.
Yeah.
And if this Ninth Amendment thing would work, well, somebody would have thought about it already. He actually said that.
Yeah.
As if it's just too much for the court to consider. But as you were talking about the word liberty, which they did in 1973 and just a few years ago in 2015, isn't isn't redefining the word liberty a pretty radical move?
Yeah, that's pretty radical.
I mean, you want to talk about something that's like big and radical. Well, gosh, the Ninth Amendment is an amendment of the Constitution.
Yeah, that's right.
What's so crazy about considering one of our original 10 Bill of Rights?
That's right. And saying, I think you overlooked this one. You never considered it. Why? Because nobody's ever argued it. Well, that's the new question. That's the equally rare precedent. And I had a guy once criticize me. He said, David, you remind me. He said, you're a true conservative. He said, I once heard, I don't know if it's Will Rogers, but he said, a true conservative is somebody who believes you should never do anything for the first time. and that's sort of the point, isn't it? The liberals are willing to argue for a liberty that's never been heard before. And nobody said, that's crazy. Liberty shouldn't. I mean, we all know what that is. It's been since Blackstone, liberty means this. It doesn't include abortion. It doesn't include marriage. Go away. Do liberals say, well, no, well, you're right. We've never tried that before. We've never argued that. That's pretty extreme. But conservatives will do that.
Yeah.
We'll actually ask for you to go back to the original conservative interpretation, and we're afraid to do that because it's too extreme.
Yeah.
What's happened, let's just be blunt, is the states and the Congresses and the executive branches, except for President Trump from time to time, have refused to be a check and a balance on the usurpation of authority by the Supreme Court.
There you go.
They've refused to be the check and balance that the framers envisioned they would be by laying down and never trying something new and never trying to distinguish a case, and just not only taking that one holding and applying it to a different situation, but applying it to all kinds of different situations, which is why we're now issuing birth certificates showing a child has two mothers. No child has two mothers, not biological on a birth certificate. But we do it in Tennessee. Why? Because our attorney general says, well, you get a marriage license, I also guess you get a birth certificate. What next is he going to decide to do? We've refused to be a check and a balance on the usurpation of power. And boy, as a former state legislator, that bothers me.
Yep. And side note, we need to change the way we choose our attorney general here in the state of Tennessee.
Yeah, we'll talk about that another time.
Just saying.
Okay. Let's close off for today. Yeah.
Well, if you have any questions, we'd love to hear from you. Feedback, you can send us an email at info@factn.org. It's FACTN.org. And until next time, be safe out there.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.